Welcome once again. This is Professor Geta Pujol from UCF, and welcome again to Legal and Ethical Environment of Business. As you've noticed, we've been doing a deep dive into some of the allegations in the complaint that the Winklevoss twins made against Mark Zuckerberg when they took their case to court. And we've really been focusing on contracts and breach of contracts. Why? Because that's really important in the business world. Businesses, one way of defining the business firm is as a web of contracts. Firms will have contracts with all manner of other firms and customers and suppliers and banks, and those contractual agreements, right? There can be consequences if those are enforceable and they're breached. Now, the other major allegation in the complaint is fraud, or more formally known as the tort of fraudulent misrepresentation. Now, and you can see where the Winklevoss twins, where they seem to have, even if there's no enforceable agreement, let's say there's no consideration, or the court might be reluctant to apply promissory estoppel, even if there were no contract, you could argue that it does look, at least the movie portrays it this way, right? That Zuckerberg at some point, it seems to be, or Jesse Eisenberg who plays Zuckerberg, right, seems to be, hey, wait a minute, I'm going to stop working on the other website that I promised to complete, but I'm going to pretend to be working on that website, but really I'm working on my website because I want to launch first. I want to have a first mover advantage in the Harvard community. I want to be the first campus-wide social network out there. I will tell you, fraud, the law of fraud, like the law of contracts, is very different from ethics and moral philosophy. Right? Moral philosophy, and I will tell you, reality, moral philosophers debate when it's ethical to tell a lie, but the general consensus is, don't tell lies. Telling lies, deception is bad, right? But legally speaking, it's just not enough to tell a lie. You're going to have to show a number of elements in order to prove fraud. So yes, telling a lie, a misrepresentation, a misstatement, that can be the basis of a fraud claim. But actually you have to prove so much more. And here what I've done is I've simplified this. Different states, because this is all common law, different state courts have interpreted fraud and the elements. The wording can be a little bit different from state to state. But the essence of the common law tort of fraud is this, that there be not just any old misstatement or any old lie. There's got to be a material misstatement. It's got to be an important one, a substantial one, or to use the language of the law, a material misstatement. So small lie about, maybe a lie about some small property of a product you're selling, if it's not essential, if it's not material, if it's irrelevant, may not be considered actionable, may not be a civil law tort. It's got to be a big lie, a material misstatement, a material misrepresentation. That's what we mean by the word material. Often in the context of the sale of a security, under federal law, this is often known as the requirement of scienter, S-C-I-E-N-T-E-R, scienter. The idea that when a company is selling stock to the public, that there's got to be a material misstatement about the value of that stock. Now, that's not all. You also have to make a misstatement of fact. So anything that's opinion-based, it's not fraud. You're entitled to whatever opinion, and you can give any opinion you want, even an opinion that is untrue. But what you're not allowed to do, legally speaking, is make a material misstatement of fact. Now, you can see where this could lead to a lot of litigation. How do you distinguish between fact and opinion, right? And this is a really important thing in journalism, right? How do you distinguish fact and opinion, bias, and that kind of stuff, right? That's something for another day. But legally speaking, right, the misstatement has to be material and one of fact, not just the person's opinion about what they're talking about. Here's another requirement. The party who's the victim of the fraud, he or she is going to have to show justified reliance. That in fact, it was justified for him or her to rely on those material misstatement of facts. I think the idea here is that if it should have been obvious to you that the fact is, that the misstatement of fact was glaringly and obviously wrong, it may not be justified for you to rely on that. You have to do your own homework, that kind of thing. But notice, it's got to be justified reliance. And finally, in order to prove fraud, you also have to prove economic damages, loss. That in fact you lost money because that you believed in the fraud and acted upon it. So it's not enough that somebody tell a lie. It's got to be a material lie, a lie about fact. You have to be justified in relying on that lie or false statement or deception. And you also have to show damages, that you suffered some economic harm or consequences or loss because of that fraud. And as you can see, if you were to apply these elements to the Winklevoss case, well, this is actually my second question to you in this week's discussion post. Do you think the Winklevoss twins can, or had the case gone to trial, could they have proven all four of these elements? If you look at it, it's not entirely obvious. All right, well, thank you for your attention. I'll do one bonus video on human vampire contracts after this. Thank you, and have a good day. Go Knights.